Good morning, everybody, and thank you for joining us this morning. I know Stephen and I were talking about this. The kickoff of webinars is usually everyone's still trickling in. So this is being recorded, and we will host this up on our website. My name is Angie Hughes. I'm with Producers XL, and I'm very excited to have Stephen Alloy with us from Mutual of Omaha's advanced sales team. And not only did we have a personal call about the buy sell and the Connelly versus US and how the Supreme Court came down on this. But we thought this was incredibly relevant. One, because we work with a lot of property and casualty agents. And so we realized that a lot of you have commercial books of business. That lends itself to being business owners. Some of you may or may not have conversations about buy sells, but this couldn't be more timely and relevant because if you're not having those conversations, it's probably time we start talking about that with our commercial accounts and our business owners. And for those of you that aren't property and casualty, but have small business owners that you're working with, definitely a conversation because this is very altering in the way these business owners are structuring their buy sells. And it's very impactful. And as Stephen and I had talked about earlier, for those that have an entity purchase buy sell, there needs to be some conversations, and it's going to involve basically a team of folks. And part of that team is going to be that insurance agent. That's you. And so bringing you up to speed about how this was impactful to small business owners and how their buy sell is structured is something that we thought was very relevant to bring to you so you can have those conversations with your policyholders and with your clients. So Stephen, I want to thank you so much for coming on with this, and thank you for having that personal conversation with us here at our agency as well. Very timely, and you're still having these conversations, and this was actually impactful clear back in June. So I would suspect that we will kind of continue to see these conversations as people are starting to get in line with their attorneys and their agents and designing how they're going to either restructure or structure their buy sell going forward. So I'm going to go ahead and mute myself. I'll jot down notes for those of you on the call. If you have questions for Stephen, we're going to go ahead and keep this to an hour. There's a chat that you can add those in, and I will monitor that chat box for Stephen, and we'll get to those questions at the end so that we can ask that. And if something happens to be very timely, Stephen, I don't think you would mind if I kind of threw in a question here or there
Oh,
if we have
yeah, not at
them.
all.
So
No, that's fine.
wonderful. So thank you very much for joining us, and I'm going to turn it over to you.
Well, thanks, Angie, and thanks everybody for joining the call this morning. As Angie said, this really is a dramatic change in business planning. And one of the things, I tend to focus in business planning in the advanced markets area here. And one of the things about business planning is most of the concepts are pretty evergreen. They don't change that often. I mean, tax law changes all the time. Retirement plan rules change all the time. Business planning really doesn't change that often. It's pretty consistent. Well, this is one of those times, unfortunately, where it did change. It was presented with the Supreme Court was presented with a case that had some challenges, had some maybe people involved in the case that didn't follow their own agreement. And unfortunately, I kept hoping as this case was moving forward, I kept hoping, well, they'll find a way to have the Conleys, if you will, lose this case because they did all this stuff wrong, but the concept won't lose. That's unfortunately not what happened. So let's talk a little bit about it, and probably just as importantly, just as important as why it's a major issue is what do you do now? What directions do we go? What directions do we go for a new buy sell? What directions if you've got an entity buy sell already? So let's get started here. A little background on the case. I'm not going to go into too much detail, nauseating detail on the case, but it came down June 6th of this year. And basically the Connelly brothers, or two brothers, owned a business. They actually had a wait and see buy sell agreement and did not opt for the cross purchase option, which is typically the first option. Basically a wait and see. You have the cross purchase option, and then if the surviving owner doesn't want to do it as a cross purchase, it defaults to the company. A lot of us wish they had taken that cross purchase option, and this case never would have happened. It would never would have gone to court. They didn't. They took the entity option, and they actually had the policies typically with with a wait and see buy sell. Typically, they would own the policies like a cross purchase, but it was one of the things they did wrong. They had the company owning the policies, so they took that entity option, company owned policies. It was challenged by the IRS on an estate tax basis for the deceased brother, for the Michael Connelly, I guess it was the deceased brother. And the IRS said that the value of his estate should have included the value of the death benefit of the life insurance that was in the business or came into the business as a result of his death. You know, as this case is moving forward, and then it hit the Eighth Circuit Court of Appeals, Federal Court of Appeals, and they agreed with the IRS. They said, yes, the value of the business should include the value of the insurance and not have the corresponding, reduction for that obligation to buy out the shares. A lot of us hoped, hey, the Supreme Court, they'll figure this out. I mean, this is clearly wrong. That, yeah, okay, the insurance does come into the business, so that could be considered an asset of the business, but there's that obligation to pay the insurance out that reduces, and if it's the same amount, it zeroes it out. I mean, that's always the way it's worked. Supreme Court unanimously, and I don't know if many of you follow the Supreme Court. There haven't been a lot of unanimous decisions in the last couple of years out of the Supreme Court. This one was unanimous. And they all agreed that, yes, that does add to the value of the business, and no, the obligation to buy the shares is not, and the way they worded it is, not necessarily a liability that reduces the corporation's value back to, so it wouldn't zero out. That concept is kind of a problem, because if you think about it, they're recognizing an obligation. Let me back up a little bit. The life insurance proceeds on the date of Michael's death were not in the company. I mean, our claims area is good. They're not that good. And this was not our policy, by the way, with this, which I'm glad, but, no claims area has the proceeds in there on date of death. I mean, nobody's asked, right? So it was a promise. It was an obligation on the part of the insurance carrier to pay those proceeds. Just the same, there was an obligation on the part of the company to pay those proceeds out to whoever Michael's heirs were, his, spouse, kids, whoever they were. And that wasn't paid out at that time either. So effectively, they're counting as an asset a promise that wasn't there yet, and they're not counting an obligation to pay out that wasn't there yet. So they're recognizing one future asset and future increase, and not recognizing the future debit on the other side. And the language, not necessarily. I mean, that unfortunately is going to lead to, it makes everything a fact question. Well, if it's not necessarily, is it in this case? Is it in that case? Is it in that other case? This is going to drive an awful lot of buy-sell agreements into litigation, just because it's not clear. I mean, you said, well, it could be, but maybe it is, maybe it isn't. Not, as you might be able to tell, this is not one of my favorite Supreme Court decisions. So this is how entity buy-sells always work historically. I mean, they've worked this way as long as I've been involved in the industry, and then, I've been around for a while. So they've worked this way for a very long time. You take ABC company, it's worth $1 million. You have two owners, 500,000 each. One owner dies, 500,000 comes in the company. They redeem the shares for 500. So yeah, okay, the money comes in, but then the money goes out, and you count both. So when you're done, it's still worth $1 million. Now you've got one owner, but the company isn't worth more than it was before. That owner owns more than he did before, or he or she did before, but company is still worth $1 million. Well, now under Connelly, if we have that same company, two owners, million value, 500,000 each, the 500,000 is added, but the redemption, well, may or may not, but let's say doesn't, it didn't in the Connelly case, doesn't zero out that addition. So ABC is now worth 1.5 million. So you may say, well, who's that really going to impact? And I think very clearly it's going to impact anyone who has an estate tax liability. I mean, that's literally the Connelly case. It's going to impact anyone any business owner who has an estate tax liability and has an entity buy sell. For some thought initially that, hey, this really only is an estate tax problem, but no, it isn't, unfortunately, because of that math. Because what can happen now, and what I think is likely to happen in a lot of cases, is that the executor of the estate, as a fiduciary for the heirs, will know about or will find out about the Connelly decision and will say, as a fiduciary, I'm bound to do the best for the people I'm representing, for the heirs. I think a lot of them are going to say, well, if the business is worth $1.5 million, we can't take 500,000 for it. We need 750. So that could wind up in litigation. It could wind up, maybe they reach an agreement somewhere in the middle. It's going to be more expensive for business owners to have that succession, have that business succession that, was pretty well established and pretty smooth prior to this case. So I think it's going to result in a lot of litigation and a lot of really uncertainty with business owners. And we'll talk maybe about there may be some ways around that. Certainly for new agreements, there are many ways around that, but even for existing agreements, there may be some ways around that. We'll talk about that in a minute here. So a lot of people, right after this happened, a lot of people said, well, what do? I'll write my congressman. I met him a couple of times. We sort of know each other. Like, well, go ahead. I mean, won't hurt, but unfortunately, it's like my old civil procedure professor said many years ago when I was in law school. He said, Supreme Court's not always right, but they're always final. So I think, unfortunately, now there could be legislation in Congress. So, writing your congressman isn't necessarily, a waste of time, but, that might ultimately lead to something, but short of legislation, it's going to take another court with a similar case to overrule this. And I think what that means is, at least for the time being, and maybe for a very long time, like it or not, we're stuck with it. We're stuck with the Connelly decision. I think anybody who's looking at a new buy sell now, little background, I practiced law for a number of years prior to coming into the insurance industry, and did a lot of buy sell agreements. And I wrote a lot of entity buy sells because they were easy. They were simple. They were easy for the business owners to figure out. If you had disparity in health or age, it was a nice way to kind of get around that issue. They're pretty straightforward, pretty simple. Well, if I was practicing still, I can't imagine a scenario where I'd write an entity buy sell just because of that risk involved. I mean, yes, they're still simple, but I don't want to put the business in a situation where there might be an addition to value that they haven't insured for, and they have to come up with more money. Another thing, not to spend too much time on the opinion, but one of the things in the opinion, there was a footnote that said that not every redemption obligation, so that there could be redemption obligations that did reduce the value. And the example they used is, well, if they'd use corporate assets to redeem the shares. And when I read that, I thought, well, now wait, aren't you saying that the death benefit is a corporate asset? So aren't they using corporate assets when they do that? Isn't that kind of what they're doing? again, a very confusing opinion, but unfortunately one that we're stuck with. We are glad, our department, we're glad to review any existing buy-sell agreements. And I probably should emphasize, my manager would certainly appreciate if I emphasize that we can't rewrite them. I mean, we are lawyers, we can't be your client's lawyer, but we will review them, and we may have suggestions saying, hey, why don't you have your client talk to the lawyer about this, or what's this section all about, or why, maybe make this change. So we're glad to do that. And so, we're glad to have that review. If you have business owners you're working with who have a buy sell that they're concerned with, doesn't necessarily have to be an entity buy sell. It could be any buy sell that they're just interested in or concerned with. So speaking of other buy sell structures, I guess the one good thing that I can find about this Connelly decision is it doesn't impact the other buy sell structures at all. It really just impacts company owned life insurance policies in a buy sell. So the other structures, cross purchase is another one that, depending on the number of owners, if you have 2 owners, even 3 owners, cross purchase is still pretty easy to do, still pretty straightforward. Did a lot of those back in the day as well. So that's probably the number one go-to as an alternative, is doing a cross purchase. And if you have that disparity in age or disparity in health, maybe some kind of bonusing or something within the company, there's probably a way to equalize that within the company and work with their accountant on that. But that can be done, and that would be a better approach really than taking their chances with an entity. If they're structured as a partnership, or if they create an entity that's structured as this taxed as a partnership, like the insurance LLC, for example, then they have some other options. They can, particularly if they use with and not to go too tax geeky on you, but there's a section of tax code about allocation provisions within partnership taxed entities. And if they use those allocation provisions properly, again, they got to work with a good attorney on this. If they use those properly, the entity might still work. And maybe even beyond that, if they're taxed as a partnership, they don't have to have the entity own the policies. They can own each other's policies. They can own their own policies. In fact, we have a structure we call it the living benefit buy sell. Other carriers call it by different names. The cross endorsed buy sell, I know, is one, and the own your own policy buy sell. They own their own policy, and they just do a collateral assignment to the other owner or owners. So those are options if they're partnership taxed, or if they create an entity that is partnership taxed, that would then, what that entity would do is that entity would manage the buy sell for the operating company. So that's an option as well. Another one is the trustee buy sell, which, for years back, we used to hear about those. I really haven't heard about one in a while, but they might be making a comeback. That's basically where it's similar in some ways to the insurance LLC if the entity owns the policies, but it's basically they set up a trust, and the trust manages the buy sell for the operating company, and there's a trustee, an independent trustee, who manages the policies, and the trust is the owner of the policy. So that might be making a comeback as well. So I think the partnership taxed entity, that is an additional step. But one of the nice things about that is that they can use this owning their own policy structure. One of the pluses of owning their own policy structure is that a lot of, business owners, you do need the death benefit protection, because not every business owner makes a living exit. One of the Connelly brothers didn't. So you do need that death benefit. But really, if you look at actuarial tables, and not to be too, that's even worse than the tax code. So not to be too boring with that, but if you look at actuarial tables, most business owners make a living exit. It's about 2 to 1. So for the 2 out of the 3 who make a living exit, using this structure, owning their own policy, can let them build cash and yes, you can build cash in a company-owned policy, you could build cash in a cross-owned policy, but when you want to transfer that tax to the insured in either of those other structures, there might be a major taxable event. Could be a taxable event for the owner or even both owners, or the owners and the company. So if they own their own policy, it's like any other individually owned policy, and it bills tax deferred. They can take it out through tax-free loans. It's a way of preparing for retirement and building cash for retirement in a tax-free bucket that is going to stay tax-free, that you won't have a taxable event getting a hold of. So another nice thing about partnership structure is that it's a lot easier to transfer policies. You can transfer or do a collateral assignment or do an endorsement to the other partners in a partnership, whereas in a corporate structure, co-shareholder is not an exception to the transfer for value, and that's why you would want to. That's why this is an advantage. Is in a corporation, if you want to transfer to the co-shareholder, that's not an exception to the transfer for value rule. See, any of these transfers are technically transfers for value, but if they fall within the exceptions, then it doesn't create a taxable death benefit. Co-shareholder is not an exception, so that would create a taxable death benefit. So that's the reason for the partnership structure. And again, as I mentioned earlier, the allocation clause is used in a partnership. I got to say we don't 100% know, because this is still new. We haven't seen cases on this yet, but I think there's every reason to think that if the allocation clauses in a partnership tax entity are done well, are written properly, I got to think that would work. So, and basically what that would do is that would allocate, if they do an entity-owned policy, that would allocate the insurance to one or another partner, depending on, on how they want to structure. So that should work, but I guess we'll find out here in the next few years probably. So again, the living benefit, the owning their own policy, is a way around this for if they're partnership taxed, or if they can create a partnership tax entity. Just again, to create that retirement supplement and not have a taxable transfer that could wind up being a pretty big taxable event. For those that don't want to do that, I mean, really in some ways the simplest, or well, almost as simple as the entity is probably the simplest, but the almost as simple as the entity is the cross purchase. One of the big advantages of the cross purchase that you don't get in the other structures is that the surviving owner or owners gets a step up in basis on that part of the business that they bought from the deceased owner. And that could be, depending on the company, depending on the basis of the company, that could be a very significant tax savings if they ultimately sell the business. Probably the only drawback to a cross purchase is if you have a large number of owners, and probably even more complicated is if you have a large number of owners with widely varying percentages. Like you've got 5 owners and one owner owns 54% and the other 4 divide unevenly the rest. It can get a little complicated, and it can wind up being a lot of policies. So basically with 2 owners, you just have 2 policies. It's just like the entity, except it's owned by the other individuals, rather than the company itself. You have 3 owners, a little more complicated, needs 6 policies. You get 4 owners, then you're looking at 12 policies. At some point, it gets probably unmanageable. But I don't know. I've heard some attorneys in the wake of Connelly saying, I don't care how many policies they need. We're doing a cross purchase. So, I think we may see some of that in ownership structures that we wouldn't have seen it in, prior to Connelly. But again, probably the other good thing about cross purchase, the other big advantage, not touched at all, not impacted at all. In fact, the opinion even says, hey, they could have structured it differently. They could have done a cross purchase. So we have reason to believe, that the Supreme Court would not rule against cross purchases at some point in the future, but who knows? I mean, I didn't think they'd rule against entity purchases either. So yeah, we never know, but that was somewhat encouraging for cross purchases. So what should a producer do now? As I've mentioned, I think reviewing the buy-sell agreements are really critical. And they may be fine. And if they're fine, we'll tell you they're fine. And if you don't need to make any changes, we'll let you know that. But I think it's important to have business owners review those. And some of them may have standalone agreements, but most of the time, I think the buy-sell agreement is really contained in their original either shareholder agreement if it's a corporation or members agreement if it's an LLC. And so we'll be glad to review those agreements and the buy-sell portions of those. It's always been important that the client work with good legal and accounting advice. I think it's never been more important than that. I think it's even more critical in light of Connelly that they get good advice and actually follow the advice. One of the problems with Connelly, there were a lot of problems with the way the Connollys handled it, but one of the problems was they didn't really follow the terms of their own agreement as far as deciding on value each year. Now, had they done that, would that have made a difference? I don't know, but it wouldn't have hurt. It might have helped. It would have been one more thing in their favor. So, getting good advice and actually following that advice. And, so some people have asked, well, what if somebody has an entity buy sell now? What do we do? I mean, do we just change the policies? Don't do that. That could be a very expensive in terms of taxation. That could be an expensive move to transfer the policies. Could be looking at transfer for value. Could be looking at taxable events and transfer for value. So don't move the policies. But maybe if you've got the agreement, I mean, if it was just done not that long ago and everybody's roughly the same age and they're still insurable, hey, maybe you just start over. For a lot of businesses, that's not going to work. They did this 25 years ago and it's going to be a lot more expensive and maybe somebody's not even insurable anymore. In cases like that, and I suspect that's going to be most of them that are out there, I would suggest, and again, you got to work with an attorney on this, but I would suggest having an attorney review that agreement with the idea that we're now going to pretend that we all live in community property states and we're going to have the spouses or other heirs agree to their formulation. Well, two things. They need, particularly, I mean, really for any buy-sell, but particularly for entities in light of Connelly, they need some kind of formula or some kind of mechanism for determining value. I wouldn't go with fair market value because that's going to include the life insurance. If they have a formula in there, that might help certainly. Again, not 100. I don't know that 100% because we haven't seen that case yet, but we probably will here shortly. But that should probably work. And then having the heirs agree to that. I think that takes out, when I was talking earlier about the executors as fiduciaries seeking the higher value, that takes that away. That part, that's worked in community property states for a long time. So I suspect that would work, that part. Now, I'm not sure about the other part, but I'm pretty sure that part would work. So I would suggest that with people that have an entity buy sell in place and just aren't in a position where they can't start over. I mean, they did this long enough ago and health has changed and ages have changed and everything. So and again, they should work with their attorneys. I mean, again, we are attorneys, but I'm not necessarily giving them legal advice, but they should ask their attorney about that because I think that would work, I think. So we have more to come on Connelly. We're revising, as you can imagine, we're revising all our marketing pieces on buy sells, and particularly on the living benefit buy sell. We had actually, I think, made a nice innovation in the owning your own policy, because most of the carriers that promote that concept talk about it's got to be a partnership taxed entity, and they say, you had to do it this way, and had to either be a partnership already or set up a partnership tax insurance LLC. Well, we were looking at that and we decided, as long as you're doing an assignment and an exception to the transfer for value is an assignment to the corporation that you are part owner of, why don't we just do an assignment to the entity, and then you do it as an entity buy sell? Hey, nice innovation, but unfortunately, they closed the door on that nice innovation. Don't do that now. That wouldn't work. So we're back to, unfortunately, having to have that partnership entity. But so we're changing the presentations to reflect that, to show that change in buy sells. And again, buy sell reviews, we're glad to do. Just let us know if we can do those. We are preparing some additional training like this, and then some additional training on buy sells, and on maybe, we haven't specifically come up with a Connelly rescue presentation yet, but that could be in the offing, kind of along lines of what I was just talking about, modifying the agreement. So we're glad to help you out with any existing cases or new cases. Glad to do reviews on cases that have been around, that you've had, the buy sells, I should say, that have been around for a while. And with that, I don't know if there are any questions. We got some time here, so if there are questions, be glad to answer them. This is our advanced markets team here. We look so good. And these pictures were taken a couple years ago, as you can see. But we look so good.
And your advanced team is fantastic, Stephen. I mean, it really, I think I've spoken to each and every one of these folks at least one time for something or other. What you covered today was probably, for a lot of the audience, intense, right? It's a lot of information.
Yeah.
I think when I step back from this a minute, I think what the outside of the final ruling, right? Because the U.S. Supreme Court gets the final rule. Is the fact that they're actually looking into life insurance, right? So they're now sneaking into our industry, and I don't know if sneaking is even the right word, but they're looking at that, and now they're saying it's actually increasing the value. So even the more life insurance you buy, that's just basically leveling up the more value to the business on an entity purchase. So, kind of unwinding all of these things and having these conversations, I think if I super, super simplify this down to the audience, what I'd like to leave with them is, you don't have to know all the legal jargon. As Stephen said, that is absolutely 100% on the client's attorneys. They write the documents, they put that in legal, terms, everybody abides by that. We are just filling the need with the life insurance to support that buy sell upon the death or exit of a partner. So don't think you have to understand or know everything that Stephen said, but it's fantastic that he gives us that backdrop to what that is. And you even kind of mentioned that step up in basis. And I can remember there was not too terribly long ago, that kind of was a political football being kicked around, is that going to go away? What does that look like? And that becomes very, very impactful, because again, now that does truly impact a lot of the folks that our agents work with on the daily basis, whether they realize it or not. So these are kind of the things, and what we always try to take away from these is the life insurance. What we do as agents, insurance agents and brokers to our clients is really, really important. And this may have felt like a very complex, which it is. It's a very complex topic. However, us being there as a part of that client's team of advisors, they need the attorney, they need the accountant, they need you as the insurance agent, because the life insurance has to be sold and it needs to meet the needs to fill that buy sell, to fund that buy sell. So don't be afraid to your business owners to just have the conversation. Hey, I'm curious, do you have a buy sell in place? If so, how is that structured? Is it a cross purchase? Is it an entity purchase? If they say it's an entity purchase, just simply lay out to them that they probably need to have a review of that
Yeah.
because of the Connelly case. And they're not, I don't think the average consumer has a clue about what that is, but
Oh, no.
you could very much be opening the eyes and helping your client recognize what could potentially be a very severe consequence to them as business owners when they had all the best intentions. I think the Connelly brothers had all the best intentions.
Yeah.
It just wasn't executed properly.
Yeah.
There was just a lot of failed steps in that entire situation.
Mhm.
And unfortunately, it allowed the IRS and the US Supreme Court to get in there and go, look, this just isn't going to work. So luckily, we have lots of other opportunities to help unwind those or to help fulfill those needs. And Stephen, you've given us lots of that information to do that. I don't see anything in the chat. I'm afraid that some are
Wait a
probably thinking,
Right.
look, I don't even know how to formulate an
Yeah.
educated question or response to this. So
Mhm.
I just say we'll step back from this. We'll let this kind of sink in
Mhm.
and just know that if you're working with small business owners or business owners, and they say they do have an entity purchase buy sell, let that be a flag go up to say, hey, we probably need to review that because of this situation that occurred.
Yeah.
And it
No, I
might give you an opportunity for more life sales.
Yeah, oh, absolutely. That's a great thing about buy sell review. It's almost like a policy review. And if you
Mhm,
wind up including the policy review as well, it's a chance to maybe get some sales. Say, hey, is this still the right amount? And oh,
mhm,
that personally owned policy that we had talked about, where are we with that? And you get back in front of people and maybe get some additional sales. Um, and I would, one of the things you mentioned, Angie, about the you know, going forward with companies and what the IRS and what taxation may look like. One commentator, at least that I've heard, has suggested that the fact that this was unanimous in a court that really there aren't that many unanimous decisions in this court, and the fact that it was unanimous is somewhat going to give the IRS you know a weapon, if you will, a way to go to businesses and enforce this and challenge this. And it's almost like saying, we're not going to stop you if you do. So, uh, yeah, I think this is going to be, I mean, at first, a lot of people thought, oh, it's just for estate taxes. And yes, I think if you have an estate tax liability, you've got two problems here with this. But,
mhm,
it's no, it's for any entity buy sell, even if there's estate taxes are the least of your problems.
mhm.
This is
And
still a
there's
problem.
so much more to come on this, right? Like you had
Yeah.
mentioned,
Oh yeah.
you're going to see a lot more, I'll call it fallout from
Yeah.
this
Mhm.
as
Yeah.
more of this comes to light. And
Oh
not necessarily the Connolly case, but just as more entity purchase agreements start playing out, I think you're going to see a lot more fallout from this as well. So,
oh yeah, absolutely. Absolutely. There'll be more cases. And just another thing about business planning, I mean, typically buy sell cases, there was one of the Blount cases that basically held the opposite of this, that now is no good anymore, I guess. That's about the only other buy sell case I can think of that ever made it to the Supreme Court. I mean, they don't make it to the Supreme Court. They're not, they usually aren't litigated. They're agreements. That's why you have the agreement. Well,
yeah, don't
I
we
think
wish the Connolly case would have just stayed in litigation?
I wish, oh, if they had taken that cross purchase option of the wait and see, I mean, they may have still had an estate tax issue, but
Mhm,
none of this would have happened. We wouldn't have had this
mhm.
rule. They might have still paid more estate tax, but we wouldn't have had that. We would have lost this concept.
Stephen, this is fantastic. I still don't have anything in the chat box, so we'll
Mhm.
go ahead and adjourn our webinar. I really
Okay.
thank you. I'm looking forward to more of the content and the information that the Mutual of Omaha Advanced Markets team comes up with, because you guys do put out some wonderful
Oh, thank
collateral material that we can all learn from,
you. Mhm.
study up on, and then share with our business owners to kind of help bring some things to light for them. So thank you very much.
Well, that's all right. Thank you. Thanks everybody for joining the call too.
Absolutely. Thanks. Have a great day.
Oh, thanks. You too.